Law, Professor Roger Alford will introduce our first panelist for the International Law, Human Rights, and the Rule of Law panel. So I'll hand it off to him. Thank you.
Thank you. It's a great privilege to be here and see so many of my students looking so nice. Welcome to this conference and this event on international law and the rule of law. And thank you, all of you, for the incredible amount of work that has gone into this, the students and of course, Meryl and O'Connell and all of the others that were involved in this. And I'll obviously thank you to the Dean for supporting this as well and giving those opening remarks. So the rule of law is a critical question that is facing every country in the world, and it's a perennial problem. It's an issue that we've struggled with for generations. One of America's founding fathers, James Madison, in Federalist 51, offered a definition of the rule of law that I think is really helpful. In 1788, he wrote, "Government is the greatest of all reflections on human nature. If men were angels, no government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself." So the rule of law is the combination, as Madison would say, between enabling the government to control the governed, but also finding ways for the government to be obliged to control itself. If you examine the various definitions of the rule of law around the world, I think there are four key components that emerge with respect to the rule of law. First, the rule of law requires a system of government in which all persons are accountable under the law. A second component is that the system of government is based on fair, published, and stable laws. A third component is fair, robust, and accessible legal process pursuant to which rights and responsibilities based in law are evenly enforced. And then in fourth, the rule of law requires competent and independent lawyers and judges. Those four, I think, are great indicia of the rule of law: accountability, stability, fairness, even-handedness, and independence. All of these, I think one can say, are hallmarks of the rule of law. It's also, rule of law is of value in and of itself, but it's also accurate to say that rule of law is valuable for human flourishing. The richest countries in the world are those that respect the rule of law. If you compare indexes of wealth and human development and sustainability with indexes with respect to rule of law, there's a correlation between those that rank really high on rule of law and those that rank on other indexes. So, for example, the 20 countries that score the highest on rule of law rankings are, with one or two exceptions, also ranked in the top 30 for per capita GDP. This correlation illustrates the link between law and prosperity. Almost every aspect of healthy economic behavior benefits from clear, transparent, and stable laws. Properly administered laws provide the stability necessary for market behavior to reflect freedom of choice. I wanted just to close my opening remarks by highlighting this index that I think is incredibly useful, the World Justice Project on the Rule of Law Index. And their methodology focuses on a few things that I just want to highlight, and then I'll introduce our speakers. They focus on what is their measurement for rule of law, and these are the following things that they say. The first principle for the measuring of the rule of law is whether the law imposes limits on the exercise of power by the state and its agents, as well as individuals and private entities. And the second principle measures whether the state limits the actions of members of society and fulfills its basic duties towards its population so that the public interest is served, people are protected from violence, and all members of society have access to dispute settlement and grievance mechanisms. And so their index, I think, is helpful, where they focus on accountability, just laws, open government, and accessible and impartial dispute resolution. This report, every year they do a report, and if you look to the United States index for rule of law, we are ranked, the United States, according to this index, 20th in the world out of 126 countries that were measured, and we do extraordinarily well on many things, particularly on fundamental rights and civil justice, but we do struggle on other metrics, and there are areas where we could measurably improve. Discrimination in criminal justice is an area where we are the lowest. Corruption in the legislature, but not the military or the judiciary, but in the legislature is an area that we struggle with. Fundamental rights with respect to labor is an area where we struggle with. So this is a really useful thing to think about, like how are we measured relative to others, and what are the ways that we could improve. So obviously today, we're going to talk about the rule of law in the context of international law and the role of international law to promote the rule of law, and we truly do have a distinguished panel of experts on that topic. So I'm thrilled to have each of you here with you, and delighted to hear what you have to say. My good friend Doug Cassel, former Notre Dame law professor, specializes in business and human rights, international human rights, and international law at the law firm of King & Spalding. So he works inside a law firm helping private clients with compliance mechanisms to make sure that they're abiding by international human rights. He's a scholar and a practitioner who publishes articles, teaches in leading law schools around the country, counsels clients, conducts investigations and negotiations, and litigates before national and international courts. He is probably most prominent in recent years in his work in mediating helping mediate the crisis, the civil war crisis in Colombia. And based on the efforts of that mediation, President Santos of Colombia won the Nobel Peace Prize. And Doug and I had a great time in, what was that, 3 years ago, in Oslo, watching President Santos win the Nobel Peace Prize based on the work for mediating peace there. And so, and Doug and the other mediators are to be credited for that work. So Doug, we look forward to your comments. Christine Cerna, also an illustrious scholar of international human rights, has a BA from NYU, an MA from Ludwig Maximilian University, an LLM from, a JD from American University, and an LLM from Columbia. And she's the principal human rights specialist at the Inter-American Commission on Human Rights of the Organization of American States in Washington, D.C. And she served as a Fulbright Fellow, conducting research at the European Court of Human Rights, and has published numerous articles on international human rights law. There's many, many other accolades that one could give of her, but she has distinguished herself as an incredible leader in the world of international human rights. And then finally, our newest human rights scholar at Notre Dame, she's only been here for a few years, but Diane Desierto joined the Keough School of Global Affairs, our newest college at the University of Notre Dame, in August of 2018. Diane truly does have a broad areas of interest with respect to human rights, and then you go down the list of a whole range of different things that she's focused on. Human rights and sustainability, human rights in our artificial intelligence, human rights in global commons, human rights in trade, human rights in investment. She is very, very active in looking at the intersection between human rights in a whole variety of different areas. She's an active collaborator and counsel in human rights and public interest related economic disputes in her in the Philippines and other countries in Southeast Asia. She's litigated before the United Nations Human Rights Commission, the International Criminal Court, and the Philippine Supreme Court, as well as the Philippine Commission on Human Rights, and on it goes. So I could stay up here and talk a long time about the three of these individuals, but it's better for us to focus on what they have to say. So Doug, you want to start?
Yes, thank you, Roger. Oh, it's good to be back at Notre Dame. I retired from here a year and a half ago and haven't stopped thinking of the place, and I'm very proud of the students here and the faculty here, and congratulations to all the students on the journal and to Mary Ellen and Roger and the Dean. It's really a pleasure to be here. I've decided, since it's impossible to speak of any one of the subjects of today's conference, namely human rights or rule of law or international law, in my brief 15 minutes allocated by Mary Ellen, I'm going to try to speak about all three of them. Because I think they are so interrelated that it's important to see that to begin with. Let's start with human rights in three aspects: in their essence, in their recognition, and in their enforcement. In their essence, human rights are fundamental. They are universal among people, if not among governments. They are inherent in the nature of human beings, and they are inalienable. They can be denied, but they can never be taken away. We all enjoy them or have them at birth and all throughout our lives, no matter how a government may treat us. Recognition is different, though. Governments do not create human rights. They can only recognize them. And the extent of their recognition is in part culturally determined and variable around the world. Enforcement of human rights depends on a combination of factors. Among others, the political and legal systems, the history and culture of a country, the kinds of human rights issues at stake, and especially the extent and nature of popular struggle to demand and enforce rights. In this country, for example, in my view, Rosa Parks and Martin Luther King and the masses of marchers behind them did more than the United States Supreme Court ever did to end formal racial segregation. So one must distinguish human rights in their essence from human rights in their recognition and enforcement. And one must also distinguish their importance in the eyes of struggling victims and communities from their importance in the eyes of governments. Failure to do so, in my opinion, led Samuel Moyn, the historian, who I think is now at Harvard, to write his 2010 book on human rights as, quote, the last utopia, end quote. The human rights moment, he wrote, has passed. Governments, he wrote, can no longer be effectively named and shamed for violating human rights. Human rights are out of fashion and on the decline, and Professor Cassel might as well pack it up and go play golf, which I don't play, by the way. If one looks only or mainly at governments, Moyn's assessment seems even truer today. We'll hear later from Professor Desierto about autocrats. Think of Duterte in the Philippines, Maduro in Venezuela, Orban in Hungary, as exemplars of the growing number of autocratic leaders who do not value human rights. And think of the current leaders of the world's superpowers, unfortunately, including this one. But at the popular level, in my experience, human rights are as important and compelling as ever. People around the world are struggling and demanding their rights, not only against governments, but also increasingly against companies, especially transnational corporations in various fields of business. In my view, a better book than Moyn's to read and to understand human rights is Arthur Kenoy's autobiographical book, The People's Lawyer. Arthur was a US lawyer who litigated many of the great Supreme Court and other cases of civil rights and civil liberties in the 50s, 60s, and 70s. He teaches, rightly in my view, that what leads social change and makes it happen are not the lawyers, but the people organized for social change. Lawyers may and should, and I would say must, assist them, but we must always remember that it's the social movements who are in the lead, and we are in a support role. Turning to the second topic, for human rights to be made effective, an essential condition, not a sufficient, but an essential condition, is the rule of law. We've heard one definition of the rule of law from Professor Alford. I'm going to say, I think, pretty much the same thing in different words. There is no single black letter law definition of rule of law, but here are some of my thoughts. Rule of law in an ideal sense means that there are laws which are democratically determined, which are accessible and in place prior to the conduct they regulate. They're not ex post facto. That all persons are equal before the law. That no one is above the law, no matter who his friends may be, or who he may be, or she. And that the laws are subject to review and enforcement by independent, impartial, capable courts, which are free from both financial and political corruption or intimidation. Now, of course, this ideal is rarely, if ever, fully achieved in practice. But the further we stray from it, the less rule of law and the weaker the safeguards that rule of law can provide for human rights. But there's also a feedback loop. Rule of law is essential for human rights, but human rights are also essential for a rule of law worth having, as Roger pointed out when he referred to the fairness of the content of laws under the rule of law. Where the laws are unjust on their face, think of the racially discriminatory laws in the United States a few decades ago, or the apartheid laws of South Africa, or the laws of countless repressive regimes around the world. Those laws need to be reformed, or the lawmakers need to be thrown out. Human rights provides a higher standard than mere law. One way human rights can serve to overturn or remedy unjust national laws, and I'm now turning to my third topic, is international law. And I refer especially to international human rights law, international humanitarian law, international criminal law on topics like genocide and crimes against humanity, international labor law, and international refugee law, and similar subjects of international law that in one way or another set norms and create mechanisms of protection for human dignity and worth. International law has its weaknesses in its norms, its protection mechanisms, and its enforcement, but it often provides a critical lifeline for peoples, communities, or individuals oppressed by national or local leaders who do not respect human rights. And we'll hear about one of those methods from Professor Cerna in a few moments. International human rights law will not, at least in the short run, curtail the abuses of the most powerful governments on the planet on issues which they consider vital to their security or which their leaders deem vital to their political goals. But international human rights law has saved many lives, freed many prisoners, and taught many lessons about the proper Madisonian limits on governmental power, which are then internalized in national laws, courts, congresses, and consciousness. In short, in matters of human rights, international law punches above its weight in many, if not all, contexts. It will not slay all dragons, but it makes most of them breathe a little less fire. That said, international law is not without its own problems. Just to give two examples. With regard to states, outdated and exaggerated notions of state sovereignty provide immunity from criminal punishment or civil redress to too many malefactors. And on the private sector side, international investment law privileges the rights of transnational corporations over those of the communities they sometimes exploit. Although this unequal treatment is slowly beginning to change, and that's part of my job at the law firm where I now work. So neither the rule of law nor international law are perfect guarantors of human rights. But where they are entirely or largely absent, as in Syria, North Korea, or Venezuela today, the human beings who live in those countries pay the price. And where they are ignored or undervalued by the leaders of the superpowers in Moscow, Beijing, Brussels, and Washington, much of the world suffers as a result. These, I would suggest to you, are among the important lessons that Notre Dame law students may learn during their law studies. Morality calls on all of us, including lawyers, to reflect seriously on human rights, the rule of law, and international law, and to put them into practice in our legal careers in a way that values all of God's children and all of our brothers and sisters around the world. Thank you.
My turn. I thank Professor Alford for the introduction, and as well Professor Cassel for setting up the thematic discussion so perfectly. My fundamental discussion today is reducible to one statement. The rule of law is necessary, but it is not sufficient. It cannot substitute for international law and human rights, especially in today's era with the rise and proliferation of autocracies around the world. Let me pick up on what Professor Alford said earlier with respect to the correlation between rule of law and prosperity. And in the traditional understanding, the Madisonian understanding of rule of law, this was a healthy correlation. The challenge today is that, especially based on the work of the legal scholar Brian Tomanaha, who put forward various conceptions of rule of law, there being a thick version of rule of law and a thin version of rule of law. The challenge is when autocracies succeed or claim they have succeeded in accomplishing or achieving prosperity with a thin version of the rule of law, when they are focused on the appearance of local, subsidiary, or sovereign processes or institutions, and not necessarily the human rights substance or outcome. That is the fundamental challenge we face today, because today autocracies co-opt the language of human rights. Autocracies use rule of law in its thin acceptation, and they justify the turn to rule of law in worst cases to dismiss human rights and to just focus on rule of law for the same reason that they claim this is the path to prosperity. Ironically, the UN definition follows the Madisonian version, and frankly, I think you go straight to the source, so I'm not going to repeat it. But there are two aspects to the UN definition and then the Madisonian definition of rule of law that are not present in today's thin version of the rule of law. And the aspect is this. First is the notion of accountability, the genuine accountability for human rights violations, which Professor Cassel very rightly pointed out. We have to differentiate between its value of human rights in essence and its functioning in recognition as well as in enforcement. Why is this a problem insofar as autocrats are concerned? Because today autocrats focus particularly on validating the essence of human rights, but arguing from their version of the principle of subsidiarity that the recognition and enforcement of human rights is something that should be determined only from the prism of sovereignty and subsidiarity to the exclusion of the international system. The reason why in the 2019 Rule of Law Index of the World Justice Project, they observed that 64% of the 126 countries surveyed around the world have turned to to autocratic rule in order to consolidate power is that in the end, it is also a very instrumentalized version of human rights that they're putting forward to their populations. If we can guarantee you social stability, if we can guarantee you a baseline of expectations with respect to welfare, what do you need human rights for if we're here? And that's a problem because in places like Poland, Bosnia, Serbia, Egypt, the Philippines, my home country, China, Hungary, Senegal, Nicaragua, Turkey, Honduras, there is a steady and incremental rise to autocratic rule that runs along the dimensions of basically 5 attacks on the constraints on government powers. And these are the shared constraints and challenges that lawyers have to deal with around the world today. The first is the challenge to the independence of judiciaries and how impeachment proceedings have been instituted against judges that are perceived to be deficient or not qualified or in some way politically not a check of not viable or not loyal to whichever system is in power. There's checks on and attacks on press and media freedoms around the world, where before it was about silencing newspapers outright. Now they're doing it through the cover of regulatory takeovers for allegedly not failing to register or failing to comply with securities and regulation requirements, using that regulatory cover in order to give a version of this is a rule of law takeover and it's not the suppression of media, because media allegedly is also being irresponsible. The third common attack is on human rights defenders. And we're familiar with this from the human rights space. Every person's human rights defender is another autocratic government's terrorist. So in that respect, the relabeling and the constant pressure that human rights defenders face from the targeting that happens in today's environment, which, as I'll discuss earlier, is increasingly more socially controlled and informationally controlled, makes this such a challenge when we claim that rule of law, or when autocrats claim that rule of law is sufficient and there's no need for human rights. The fourth, ironically, is on religion. And I didn't expect the Freedom House report to say this, but it actually found it in its own report. There's been an increasing attack on religious institutions around the world. And when I stopped to think about why that is exactly, if you're attacking the press, if you're attacking human rights defenders, if you're attacking independent judiciaries, and you're attacking religion, you're basically attacking all the bases by which sociability is formed, by which belief is formed, by which communities reflect and deliberate on governmental power. And to the extent that even religious institutions have been attacked and autocrats, that in autocracies around the world, this is because of their bid to consolidate power. The fifth common feature that I will add, which is also partly drawn from my earlier lecture this week at Brussels, is how all of these take place in a heightened, dangerous environment of disinformation where autocrats have used the tools of artificial intelligence, machine learning, and deep learning to pollute the information environment, to make sure that the marketplace of ideas is no longer truly a free environment, but rather is a socially engineered, informationally controlled environment. And that, in my regard, makes it all the more crucial that the kind of inroads we must be making in human rights should not just be in the recognition of human rights or in the enforcement of human rights, but also in understanding that today's autocrats don't necessarily wield the heavy stick anymore. They use the regulatory stick in order to ensure that they can neutralize and disarm any sign of feasible political opposition. This is where I turn to the discussion which Professor Cassel very rightly pointed out, the undue emphasis on sovereignty. And it's so ironic how today's autocracies heavily emphasize subsidiarity, the locality of responses to human rights issues, and how often autocracies around the world, including my country, the Philippines, goes before the Human Rights Council to say, we have local procedures. You should allow us to fulfill our own rule of law processes. And in this respect, this is undue interference by the international system. This is, in their words, human rights imperialism. And yet this falls prey to something that rule of law does not have, but human rights has. Human rights, as discussed by Professor Cassel, has universality. Rule of law, on the other hand, has only plurality. When it's a pluralism of it's my truth as the autocratic government versus your truth, and you can dismiss human rights and the centrality of human rights, our moral impulses ultimately are those that are most suppressed, and we don't even know that it's happening. This is why the common strategy that Foreign Affairs in 2019 identified in its profile of the most prominent autocrats today, Vladimir Putin, Xi Jinping, Recep Tayyip Erdogan, Rodrigo Duterte, and Viktor Orban, they identified 5 common strategies that all of these autocrats do. Today's playbook. One is to incrementally dismantle checks and balances, the same 5 characteristics I described earlier. The second is to show you have the monopoly of force and the demonstrated propensity to use this force. Only in the particular case of Duterte, slaughtering 27,000 people is enough to chill a lot of the political opposition, as well as any grassroots mobilization against the regime. The third is to reject international law and the international legal system simply on the assertion of sovereignty and subsidiarity. There's no international law system devoid from what national governments consent to. The fourth is to disparage accountability through the international system, overemphasizing the defects of the international system without recognizing the defects of the domestic system. That's almost a given. They will assume that the supremacy of the domestic system is so much more readily acceptable to a population as opposed to an international procedure that is often quite inaccessible and illegible to human rights victims. And they will also foment local mistrust of the international, and finally, distribute rewards to the military. This leads me now to think about our debates on the interpretation of human rights and interpretation of international law, and part of me thinks, did we go too far? That we ended up emboldening autocrats who were very deft in co-opting the language of rule of law and saying, see, that doesn't work. So we should be turning to our own systems, to our own local systems. In this, what I call the twisted version of subsidiarity that autocrats use, not only are there sham local investigations, threats to judges and human rights defenders, neutralizing attempts to mobilize through regulatory requirements, as I said earlier, but most importantly, it is to achieve the steady acceptance of the population through information control that life is normal, that the normal, that is a heavy hand of state control and the dismissal of the value of human rights by the supplanting or the substitution of rule of law that somehow provides social stability is going to be enough. And that's why, at least from my standpoint, the deficit from the rule of law, at least the thin version of the rule of law that autocrats put forward today, is on accountability. This is why the work of Professor Cassel and his colleagues on human rights compliance is so important, because the new frontier of activity is in the regulatory space. It is so important that we take a look at corruption, which often has been separated out from the human rights space, but in reality functions well along the autocrat playbook, as I've been discussing in the last few minutes. And lastly, perhaps it's also apt that even in our paths to try and reframe and reform the international system, much as many human rights scholars argue that we should temper our expectations and try to be as specific about what human rights can do and what it can't do, the temptation there is for autocrats to overplay the alleged defects, actual or imagined or real, of the human rights system in order to validate whatever substitution they can make by way of the thin rule of law. In that respect, I think there is still a space for international accountability, and that exists because we have a charter-based system, a values-laden international law, postmodern international law that the rule of law does not fully and adequately capture. Thank you very much.
First, I'd like to thank Professor Paolo Carrozza for not being here. And secondly, Professor O'Connell for inviting me to come and replace him. And Professor Alford for his introduction. And Professors Cassel and Desierto for giving me the last word. My presentation is going to be a bit different than the first two. It's about cases. And specifically, the title of my presentation is Provisional Measures, How International Human Rights Law is Changing International Law, inspired by Gambia v. Myanmar. I assume you all know what provisional measures are. Is that right? The argument of my presentation is that international courts, when pressured to act quickly on behalf of a victim whose human rights may have been infringed, will tend to disregard the requirements of the law in favor of doing something for the victim. Provisional measures which require the court for the human rights body to act quickly to avoid imminent irreparable damage to persons tend to be the chosen legal instrument for such action. Provisional measures are normally granted within weeks or sometimes in as short as a day, whereas a decision on a case can take years or sometimes decades. Provisional measures are defined in Article 41 of the ICJ statute as measures, quote, to preserve the respective rights of either party, close quote. Parties to what? Presumably to a case pending before the ICJ. Of the three major international human rights treaties, the ICCPR, the European Convention on Human Rights, and the American Convention on Human Rights, only the American Convention explicitly provides for provisional measures. Article 63 of the American Convention provides, quote, in cases of extreme gravity and urgency, and where necessary to avoid irreparable damage to persons, the court shall adopt such provisional measures as it deems pertinent in matters it has under its consideration, end quote. With respect to a case not yet submitted to the court, it may act at the request of the Commission. All three human rights bodies, the UN Human Rights Committee, the European Court of Human Rights, and the Inter-American Court of Human Rights, all issue provisional measures, as does the Inter-American Commission on Human Rights, although it calls them precautionary measures to distinguish them from the provisional measures set forth in the Convention, which are issued by the Inter-American Court. The imminent imposition of the death penalty has been a popular subject matter for provisional measures, both at the ICJ and before human rights bodies. An applicant requests the ICJ or the human rights body to issue provisional measures requesting the state to stay the execution of the individual on death row, so that the ICJ or the human rights body will have the time needed to complete its consideration of the merits of the case. Were the state to execute the prisoner, the death of the victim would moot whatever eventual decision was issued. So provisional measures become a kind of reality check on the formalisms of the rule of law. An eventual decision from the ICJ or from a human rights body would be meaningless if the person can no longer benefit from it. The Inter-American Commission on Human Rights, with which I am most familiar, considered the court's provisional measures legally binding because they were set forth in the American Convention. But it also considered its own precautionary measures legally binding, despite the fact that they were not included in the American Convention, but were created by the Commission itself and its rules of procedure. This upset the Inter-American Court, since the court felt that it had a legal monopoly on the right to issue provisional measures, since only the court was specifically mentioned in the American Convention. It goes without saying, however, that if the beneficiary had been executed while the case was pending before the Commission, then there would be no beneficiary when the case eventually reached the court. But wait, you might say, the American Convention allows the Commission to request provisional measures from the court, even if the case has not yet reached the court. Why doesn't the Commission do that? Well, part of the answer is that the Commission was created in 1959, 20 years before the American Convention on Human Rights entered into force, and the court was created, and it had been issuing precautionary measures for years and was not ready to stop doing so. If the state failed to comply with the measures, the Commission began to request measures from the court to ramp up the pressure on the state to comply. This was a tacit recognition on the part of the Commission that the court's measures carried more weight than its own, a generally unwise proposition for two purportedly equal bodies. The ICJ and the other human rights bodies issued provisional measures but did not consider them legally binding until they did. The change began with the ICJ's June 2001 judgment in the famous Legrand Case, a death penalty case involving two brothers in Arizona. Germany presented the case on the eve of Walter Legrand's execution and asked the court to declare that the US, and I quote, in arresting, detaining, trying, convicting, and sentencing, close quote, the Legrand brothers violated its, and I quote, international legal obligations to Germany in its own right and in its right of diplomatic protection of its nationals, close quote, under the Vienna Convention on Consular Relations. The first brother, Karl Legrand, had been executed on February 24th, 1999, and the second, Walter, was to be executed on March 3rd, 1999. On March 2nd, Germany instituted proceedings against the US, accompanied by a request for provisional measures. The order was granted, and I quote, the order said, the United States of America should take all measures at its disposal to ensure that Walter Legrand is not executed pending the final decision in these proceedings, and should inform the court of all the measures which it has taken in the implementation of this order, close quote. The wording was the same as the order in the earlier Briard case, involving the impending US execution of a Paraguayan national who allegedly had been deprived of his Vienna Convention rights. The order in Legrand was issued on March 3rd, and Germany immediately instituted proceedings in the US Supreme Court to enforce compliance. The US Solicitor General took the position that, quote, an order from the ICJ indicating provisional measures is not binding. It does not form a basis for judicial relief, close quote. The US Supreme Court dismissed the motion filed by Germany, and on the same day, Walter Legrand was executed. Although the order in Briard was identical in wording to the order in Legrand, the fact that Germany considered the order binding and the US did not led the court to examine the issue and for the first time declare that its provisional measures were legally binding. While the Legrand case was pending before the ICJ, Mexico requested an advisory opinion from the Inter-American Court, querying whether the failure to notify an alien of his rights under the Vienna Convention violated his human rights. The Inter-American Court, in its opinion dated October 1st, 1999, found that the right to seek consular assistance, quote, is part of the body of international human rights law, close quote. And failure to provide such information to the alien is prejudicial to due process, and consequently, his execution constitutes an arbitrary deprivation of his life. The public hearing on the Legrand case took place in November 2000, so a year after the Inter-American advisory opinion. Germany at the hearing, armed with the Inter-American Court's advisory opinion, no longer only argued that the US had violated international legal obligations to Germany in its own right and the right of diplomatic protection of its nationals, but that the US had violated the individual rights of the Legrand brothers. This is an interstate case, and they're alleging the individual rights had been violated and had deprived them of their human rights. The ICJ agreed that the US had violated the individual rights of the Legrand brothers, but held that it did not have to determine whether these rights were human rights. ICJ Vice President Judge Oda dissented and publicly regretted having voted for the provisional measures since they were not issued to preserve the rights of states. The rights of states in I quote, the rights of states in question must be those to be considered at the merit stage of the case and must constitute the subject matter of the application, instituting proceedings, or be directly related to it, close quote. The provisional measures ordered by the court to preserve, at least temporarily, the life of Walter Legrand were not directly related to the rights of states under the Vienna Convention, Judge Oda declared, and the court made, quote, a significant error, close quote, in issuing the order in this case. Yet even though Judge Oda declared that the court should not have issued the order, and he regretted voting for it, he added that, quote, this error was, however, quite understandable, as a human life hung in the balance, and the court was given very little time to decide upon the request for an order, close quote. This is a good example, in my opinion, from my argument that the law crumbles before the court's desire to do something when confronted by a human rights crisis. The world is watching. Do something to help the victim, then look at the law later. Next part of my presentation is unlinking provisional measures from a pending case. Beginning in 1997, the Inter-American Commission began to record in its annual report the precautionary measures it had requested of states during the year. Most precautionary measures were connected to a case, although the Commission asserted that it was free to take any action it considered necessary for the discharge of its functions, either at its own initiative or at the request of a party. In 2001, the Commission's new rules of procedure entered into force and purportedly clarified the rules governing precautionary measures in light of current practice. This clarification stated that precautionary measures would be issued in serious and urgent cases whenever necessary, or on the Commission's own initiative or upon request by a party to prevent irreparable harm to persons. What began to happen is that more and more precautionary measures were issued for individuals independent of a case and independent of its original function of preserving the subject matter of a case until it had a chance to review the merits. The mechanism became a kind of fire brigade, attempting to resolve all crises by extinguishing the fires, the rationale being that it was, as Professor Cassel said, saving lives. It began to be noticed that the Commission was issuing precautionary measures outside the context of a case, so the Commission in 2009 and again in 2013 revised its rules and explicitly provided that in its rules that it may request that a state adopt precautionary measures, whether related to a petition or not. It should be noted that other international human rights bodies do not do this. And now to my last point, which is on Gambia v. Myanmar. Gambia instituted proceedings against Myanmar in November 2019 and requested provisional measures on behalf of 600,000 Rohingya who are still in Myanmar and did not flee to Bangladesh. In 2016 and 2017, approximately 740,000 members of the Rohingya minority were brutally chased out of Myanmar by the military and security forces, who began systematic clearance operations, during the course of which they committed mass murder, rape, and other forms of sexual violence, and engaged in the systematic destruction by fire of Rohingya villages, often with inhabitants locked inside. The Gambia charged that Myanmar's actions constituted a violation of its obligations under the Genocide Convention, which Myanmar denied, arguing the absence of any genocidal intent. Myanmar pointed out that it was engaged in repatriation initiatives through UNHCR and was ready to take back thousands of Rohingya. The Rohingya, for their part, are unwilling to return. How this can be a UNHCR initiative is troubling, for if the ICJ determines that these clearance acts constituted genocide, it would be like repatriating Nazi concentration camp survivors back to Nazi Germany. The ICJ granted Gambia's request and noted in its order that for the purposes of provisional measures, it is not called upon to establish whether Myanmar violated the Genocide Convention, but simply to decide whether the circumstances exist to require the issuance of provisional measures. The ICJ's order unanimously called on Myanmar to take all measures to prevent the commission of all acts defined as genocide by the Genocide Convention, without saying that the acts that Myanmar had committed during the clearance operation constituted genocide. Again, in this case, I believe the separate opinion of ICJ Vice President Shui supports my argument. Judge Shui does not think that the subject matter of the case is genocide because of the lack of genocidal intent, the decisive element. She argued that in order to find jurisdiction under the Genocide Convention, the court must determine prima facie that the subject matter of the dispute could possibly concern genocide. Although the violations are appalling, she continues, the fact that Bangladesh is seeking a durable solution in cooperation with Myanmar indicates that the present case could not possibly suggest a case of genocide. Yet, Judge Shui's doubts about the court's jurisdiction, the standing of the applicant, and the admissibility of the case do not inhibit her from voting in favor of the court's unanimously approved order because, and I quote, there were serious violations of human rights and international humanitarian law against the Rohingya, close quote. And considering the gravity and scale of the offenses, measures to ensure that Myanmar observe its obligations under the Genocide Convention, and I quote, should not be deemed unwarranted, close quote. Saving lives and preventing irreparable harm to persons through provisional measures as practiced by international human rights bodies has also changed the ICJ, which is now trying to save lives and does not limit itself to preserving the respective rights of the parties. Thank you.
So we have about a half hour for discussion. I want to ask Doug Cassel about the positive development of the emergence of a new discipline of, not relatively new discipline of business and human rights, to the point that there now is the opportunity for human rights practitioners like you to be embedded inside a law firm to try to promote compliance with human rights by their clients. And I wanted to see if you could speak a little bit about the interesting development about the idea of human rights as as an internalized process of compliance that you're seeing in work at law firms around the world.
Thanks, Roger. The mic is on, right? Yep. The whole field of business and human rights, which is one I started writing about 20 years ago or more, and teaching here at Notre Dame 10 years ago or more. And it's probably one of the most important growth areas in the field of international human rights law today. There's not a lot of hard law. There is some that restrain private entities like business corporations from violating human rights. It's mostly soft law, but it's soft law that has some very serious teeth. And so much of my work at a large global law firm that has as its clients, like most other large global law firms, big transnational corporations, is letting them know about, first of all, the soft law, which even the lawyers, let alone their clients, are usually completely unaware or close to it. And secondly, about the teeth that come along with some of this soft law. For example, the number of, or the percentage of professionally managed equity funds in the world today that are under some form of ESG criteria, environmental, social, and governance, all three of which include elements of human rights, has been skyrocketing in the last few years. A couple of years ago, John Ruggie, who's the former UN expert on business and human rights, a Harvard professor, said at that time that the percentage of professionally managed equity funds in the world had gone up to 25%. 10 years earlier, it was probably something like 10%. 2 years have passed since then. My guess is it's over 30% today. And that makes a difference to big companies that need to make sure their stock, and to their CEOs and their CFOs, who need to make sure that their stock price stays up. Likewise, for debt capital for these companies, increasingly the big banks are under pressure, not only from the voluntary equator principles that were begun back in 2003 and that have expanded and tightened a little bit since then, that require banks to engage in human rights due diligence when they make project and related loans to big companies or to companies. But also, within the last year, at least 2 proceedings have been filed, one in the Netherlands and one in Australia, against big banks before the national contact points of those countries under the OECD, the Organization for Economic Cooperation and Development, guidelines for multinational enterprises, alleging that the banks themselves were violating human rights because they were not paying sufficient attention to the human rights conduct of the big companies to which they make loans. Now, much of this is in its infancy, but the trend is pretty much all in one direction. And my partners at the law firm, partners at other big law firms that represent companies, and our clients especially, need to be told about these kinds of developments. It's not just the possibility of bringing an international criminal court complaint against a senior corporate executive, which actually happened a year or 2 ago against one of my firm's corporate clients. But much more important is the pressure that's coming from the banks, from the equity managers, and from the insurance companies, and that pressure doesn't fall out of the sky. It is in turn a reflection of the pressure of human rights activists, NGOs, and lawyers around the world who, realizing they were hitting, if not a brick wall, at least a partial brick wall with many companies, decided to hit them where it hurts in the pocketbook. So in analyzing business and human rights, you need to look not just at the formal developments in law, not just at the process to develop a business and human rights treaty that's underway at the United Nations right now, not just at the French loi de vigilance, the vigilance law that was adopted in 2017 and that requires big French companies to have essentially human rights due diligence plans, which they make public and which they can be penalized if they don't make public and comply. Not just at the modern slavery acts that have recently been enacted in the UK and Australia, not just at other hard laws concerning other aspects of human rights, but also at the underlying funding of these companies. And this is in all these areas. Lawyers have a role to play. So it is still, Roger, I would say, an incipient field. But by the time many of these young people are my age, I think it's going to be a very, very serious field. And I hope it gets there before you get to be my age.
Yeah, one of the most exciting things about business and human rights is the idea that human rights are becoming embedded into contractual commitments. And all of a sudden now, it's not simply a treaty or a statute, but there's a commitment that is an expectation that is being imposed on investors or on banks or on global supply chains that there will be core environmental protections, core labor protections, and the idea of like expanding human rights to include contractual promises in addition to other sort of statutory and international promises is one of the more interesting developments. I want to do another question, and then I'll open up for the audience, and that is, if you talk about like the big stories about rule of law around the world right now, I think, Diane, you did a wonderful sort of broad sweep of all of the developments. But two of the most interesting ones are Hong Kong and Venezuela, right? Hong Kong and Venezuela in a lot of ways are bookend stories. They're cautionary tales about the rule of law. One could think about Hong Kong in a whole variety of ways, but in a way, it's sort of the converse of the civil rights movement in the United States, where there was an absence of the rule of law for the protections of a whole class of society in the United States. Hong Kong is sort of the reverse of that, whereas there's been this long-standing tradition and presence and promise of the rule of law with Hong Kong, and now there is a sense of erosion of the rule of law in Hong Kong, and it's like a thumb in the dam, or 5 fingers in the dam saying, we don't want to go this direction. We don't want to go this path. So in a way, it was like this amazing movement of protest to say, we care about the rule of law. We care about the law and the order and the independence of the judiciary, and we are willing to sacrifice our lives to promote the rule of law in Hong Kong. I think that the protesters in Hong Kong are a really, really interesting story about the importance of the rule of law to people where they see it eroding in their country. The other alternative is Venezuela, where one can say a lot about Venezuela, but one of the things that is clearly the case is the absence of the rule of law led to this downward spiral into the descent of chaos and anarchy and just a complete collapse of government. And it's this incredible tragedy for Venezuela, but it's also this cautionary tale for every other country that if we are not careful, if we don't respect the rule of law, we are going to go down the path of Venezuela. People say that it is the worst story of bad governance outside the use of force in modern history, right? Where there's no use of force, no civil war, but it just complete collapse of a government, in part because of the absence of the rule of law. Both of those are rule of law stories that I think hold some promise, right? That governments will be careful. Any comments on any of that?
Thanks, Roger. I think Hong Kong and Venezuela are polar stories, not just in the how rule of law is fought for or defended or in what they exemplify, but also in the nature of what state capacity, the bedrock state capacity does with respect to achieving the recognition and enforcement that Doug was talking about earlier. Hong Kong is a unique case because their own judiciary from a very long time has already had their jurisprudence directly incorporating the International Covenant on Civil and Political Rights as part of Hong Kong law. And even if Hong Kong itself is not a treaty party, its own jurisprudence recognizes that we will apply international human rights standards as part of Hong Kong. So the culture is so deeply steeped and entrenched in the notion of democracy, freedom, and rule of law that how I see Hong Kong playing out is really a concrete case of a mixed bid for self-determination, both internal and external, which itself is marvelous to see. But we can see how that deteriorated, again, because of incremental erosions on checks. It began with the attempt to try and allow or have persons who were accused in Hong Kong to be extradited to mainland China, and then to a series of erosions on individual civil protections in Hong Kong. Venezuela, for me, is different because the state capacity is so different. Much as there may be membership in the inter-American system, much as there is, a normative commitment to human rights, the state capacity is radically different. I mean, in terms of corruption, they have been higher up on the index. Hong Kong has not. There have been very different barometers of the ability to enforce and to recognize accountability, that in that respect, I agree, it's a signal example of how you could descend to chaos, but also how you could descend to chaos that fast, given that Venezuela, as an oil-rich country, managed to collapse precisely because there were no checks that human rights and rule of law would have provided. There was a nomenclature towards human rights, but there was mismanagement all around, precisely with no human rights compliance in place.
If I could add one little technical point on Venezuela. The government of Nicolas Maduro denounced the American Convention on Human Rights and also denounced the OAS Charter, the first country ever to denounce the OAS Charter. And then the OAS decided to recognize the government of Guaido, and it proceeded to re-ratify the American Convention and to re-ratify the OAS Charter. So the question of the status of Venezuela is at best a dubious one in the inter-American system.
Just to flag a question for the public that you might want to direct to my esteemed colleague, Professor Cerna. One way to look at what her remarks were about is that there is a tension sometimes between law, and in the case she was talking about international law, and specifically international law on when provisional measures are appropriate on the one hand, and human rights on the other. The broader question of when there is a conflict between law, particularly international law, and human rights, reminds us that human rights and the rule of law do not always go hand in hand. And sometimes you have to face very difficult questions. Back in 1999, Mary Ellen and I, who were acting completely separately at the time, she was off in some other university, and so was I, were among the very few voices in the US international human rights community to speak out against the NATO bombing of Yugoslavia. Most of my human rights friends said, oh, it's good for human rights, it's okay. And my position, and I think if I'm right, Mary Ellen, yours as well, was that this was a clear violation of the UN Charter, and that law has to place limits, and that law has, on the whole, been good to human rights. And if we start undermining law in the name of human rights is going to lose a very important partner. So I raise that not to give any answers on the subject, but just that what I'm hearing, the broader implications of Christina's presentation, is that you have to face the tension sometimes between law and human rights.
Great. Open up for questions. Yep.
I could speak for several hours on that, so I'll try to give a very nutshell presentation. First of all, it's not clear that the UN treaty is going anywhere. It's been promoted since the beginning by Ecuador, whose commitment to human rights, especially under the previous regime of President Correa, was not credible to anyone. It was appropriately seen, I think, as on Ecuador's part, not the part of the many human rights NGOs that supported in good faith and for good reason around the world, but on Ecuador's part, it was seen as part of their effort to bash the United States, the global capitalist system, and Chevron Corporation in particular. And I should disclose that Chevron Corporation is one of my firm's clients, and that I defended Chevron before the Inter-American Commission on Human Rights against what I consider to be a complete fraud of a lawsuit in Ecuador. So I don't think it's likely to go anywhere anytime soon, in part because it was almost stillborn. The UN Human Rights Council resolution in 2014 that got the process going was approved only by a plurality of votes. And some of those votes were dubious, to put it mildly, namely Russia, who in the first meeting after the process got underway said basically, well, we voted in favor of this to be nice to Ecuador, but we don't think it's a good idea. So the process has been troubled. It's been boycotted by the United States. It's been boycotted by Japan. It's gotten no support from any developed state, none. It's gotten tepid, lukewarm support from a small number of states in the global south. Ecuador has mishandled the process, in my opinion, by not doing what John Ruggie did when he developed the UN Guiding Principles on Business and Human Rights and reaching out and consulting with a lot of countries and a lot of constituencies. Instead, Ecuador has been playing this inside the vest. Almost nobody knows what they're up to next. They don't invite other states to participate from the panels, or rarely do, in Geneva. And the substance of the current draft is one which makes any good international lawyer choke. They needed to have some serious international lawyers sit down with their draft and try to improve it. Now, at this point, the atmosphere has become so sour that I don't know whether it's salvageable. It might be, but it's going to take a long time if it is.
My question is for everyone. I want to divide my question in two aspects. First of all, regarding the international law perspective of the concept rule of law, if it applies, first, and what is the role of the sovereignty and subsidiarity in a positive and negative perspective in the international human law perspective of rule of law? And the second question is regarding the domestic level. In the domestic level, we have countries like me, I'm from Chile, that the international human law provisions are incorporated to our constitution. In different hierarchy, but it's law, it's domestic law at the same time. And one of the concerns of the community or the citizens inside the country is what is the role of the rule of law when the judiciary use, for example, soft law as a source of legally binding law, when it's not legally binding. When we have an independent judiciary, we have a Congress, which creates law, is the only unit that have Congress, create law, not the judiciary. And what is the role of the rule of law at the domestic level? And if we can use the same concept in the domestic level and the international level.
I think I'll answer the first question and leave my distinguished colleagues for the second question. There's a deficit that I did not point out earlier in my presentation, which is when we talk about positive subsidiarity and negative subsidiarity, right? There's a circumstance where it should be the local government or the local institution that should realize, implement, enforce, protect human rights. But the flip side to that is if they are unwilling, if there is no capacity, that's why I was talking about capacity earlier. If there's no capacity, then the international community must try at least to come in. What the deficit that I'm pointing out here is the verification of that unwillingness or that inability, because that's precisely where the sovereignty angle plays in. States will say, this is a political determination of whether or not our local institutions are capable or incapable. For the international system or an international criminal court, for example, or an international tribunal to say that our processes are too long, too much of a sham, is itself a political determination that has no bearing on the rule of law. And that's when they would try to say human rights co-opts the rule of law. But if we follow the UN definition, which does track the Madisonian definition, accountability is built squarely in that process. And the way that some legal scholars have thought about it is accountability is a dialogic process that involves transparency. So if you don't have transparency on the ground with local governments, no transparency with respect to the information that's communicated to the international system about unwillingness or inability, and you see that play out in places like the Philippines, where Duterte will just say, our courts are great, our institutions are great, but we won't allow any inspectors to come in. That dialectic plays out rather unfavorably, and that's why I say it's a twisted version of subsidiarity. It's not a genuine version of subsidiarity.
I'll take on some of the second question. As you know, being a Chilean, the inter-American system has been critical in promoting what's called the control of conventionality, which is not a word either in English or in Spanish. But what has developed is actually quite fascinating, which is that many countries, and I believe Chile is one with the reform of its constitution, has identified as a block of constitutional rights, those rights that were in the Constitution and those rights that have been incorporated into the Constitution from its being a party to different international human rights treaties. And that has domesticated a lot of international law and made it enforceable in courts in Latin America. But what I think is the question that needs to be answered is, what if the domestic courts get it wrong? And one, I think, very prevalent problem has been on the issue of term limits in constitutions that have been overridden by Supreme Courts in countries like Bolivia and Nicaragua, just to name two, which invoke the American Convention on Human Rights and say that the American Convention finds that term limits violate or a violation of the convention. Which is total nonsense and something that these courts have made up for because they happen to be in the pocket of the executive, and that becomes kind of the common wisdom. So I'm happy to report that Colombia has just requested, finally, an advisory opinion from the Inter-American Court on this question. So we should be getting an authoritative answer from the court sometime in the relevant future.
If I may, two decisions from the 1980s by the Inter-American Court are relevant to both your questions. One was, and maybe they were both in the same, one was an advisory opinion in which, and I forget which one it was, maybe Christina or Diane would remember, where the court stated that there is a triad between human rights, the rule of law, and democracy. And you need all three together to make any one of them work. And that's a crucial principle. And it was either in that or another advisory opinion where they addressed the meaning of the word laws in the American Convention. Because under the American Convention on Human Rights, as other human rights treaties, essentially, this is really oversimplifying, it sets out rights and then it says that in certain circumstances, they can be restricted by law. And the question is, what does the word law mean? Does it mean anything that Donald Trump says or anything that I say? And the court answered no. It must be something decided by a democratically elected legislative body, so that executive decrees, Duterte's pronouncements, and other such efforts to substitute for law cannot justify restrictions on human rights. If you're going to restrict human rights, you've got to do it by a law. And even then, sometimes those laws, as Christina just pointed out, get it wrong.
You referred to the 2019 Forum on Citizen Human Rights and the discussion that they had there in Geneva. It was quite interesting that I had to and there was a very much a lukewarm response on the binding treaty. A lot of everyone's usual pessimistic about the future of binding treaty. But I have a almost monthly standing dinner invitation with a dear friend, Professor Williams, from the Business School. And he and I fight about this all the time, Oliver. And the discussion was around the UN draft norms in that India, and how that led to the UN global compact and Buchanan's time at the United Nations. But in light of the pessimistic approach that a lot of that UN already have, and the adoption of this binding treaty that they proposed, is it not time to revisit discussions on UN draft norms yet again?
No, not even close. First of all, while I am pessimistic as an empirical observation about the treaty process as I described, I'm working very hard together with an independent international group of specialists to try to smooth out some of the drafting problems with the treaty and to work with states to try to get more of them to be supportive of the process in a way that they have not been so far. I'm not wildly optimistic that we will succeed in that endeavor, but we're at least making the effort because we think it's important. The problem with the subcommission norms, which were drafted by the now extinct UN Subcommission on Human Rights, and largely by my good friend, a terrific guy, a terrific lawyer, David Weisbrod, was they attempted back in 2003, I think, when they were published, to, in one fell swoop, impose all of the international human rights obligations that hitherto existed for states and to say they apply to business corporations. That was not a credible interpretation of the law, frankly, with all due respect to the drafters. And it was not politically viable in the short run in the sense that it was roundly rejected by the UN Human Rights Council itself, the parent body. But on the other hand, it did have the effect of creating enough ruckus, enough noise, that the UN felt it had to do something. And this something was the appointment of Professor John Ruggie, who later developed in 2008 the UN Framework on Business and Human Rights, and in 2011 the UN Guiding Principles on Business and Human Rights, which in turn led in 2016 to the International Bar Association Guidelines for Business Lawyers on Business and Human Rights. And so all of you who are going into law firm practice, Brad, and others from the journal, would do well to read the UN Guiding Principles on Business and Human Rights, which apply to your clients, and the IBA Guidelines for Lawyers, which apply to you and to me, because frankly, 99% of the lawyers in big firms have never heard of the IBA Guidelines, and 98% of them have never heard of the UN Guiding Principles. Yep.
Two questions. The first one for Professor Cerna, and I know it's a boring question and an never-made question, but how to do with compliance and enforcement of precautionary measures when the compliance of the binding decisions of those organs is already prepared. Then my second question, I had a different
Could you say that again?
Yeah, when the compliance of binding decisions of the Inter-American Court, the ICC, ICJ, it's already precarious. How to deal with the compliance of precautionary measures, or which
Okay.
their legal standing might be also questioned by the countries which would have to comply. Then my second question, I was going to make a different question for Professor Desierto, but since both of you, Professor Cassel and Desierto, talk about Venezuela, and I'm a Venezuelan, I feel compelled to do this question. What to do when the rule of law is being subverted by mechanisms that seem to fit within the rule of law? And in the case of Venezuela, the judicial reform that ended up with the total control of Maduro's, Chavez, and later Maduro's government of the judiciary was initially hailed by international organizations, partially funded by the Inter-American Development Bank and the World Bank, and then through legal mechanisms, legal reform and constitutional reform, ended up taking down the rule of law. So how can the international community face this and have a say in procedures that seemingly are needed?
Yeah, Bernardo, I think your question is a bit like, how do you enforce international law? And there's just a little micro bit, the provisional measures. I think, like Lou Henkin used to say, most people and most states do obey the law, and that international law in a regional system of countries that are similar, they will generally respect provisional measures. It's the big powers, the US, which is in our system, never respects it. And especially in death penalty cases, proceeds to execute the individual on death row, but it's something the Commission keeps on issuing these measures because there is a trend towards the abolition of the death penalty in the world, and this is part of the work of a human rights body. There are, of course, many cases where the person that we try to protect is killed or is somehow harmed, and international law doesn't work in those cases. How do we make it better? Get more countries to respect international law. Sorry, I don't have a better answer.
Okay, I think we are out of time, so let's give, I'm sorry, you want to, no, go ahead.
Just a brief answer to this question. It's the quandary any human rights defender will face, precisely because we operate in a space where law is both interpreted in the adjudicative space, so it may seem like something has the color of law, and part of our advocacy as councils is to constantly seek to push that interpretation to what is truly consistent with human rights. The difficulty with incrementalism is precisely because it happens in pockets. Judicial reform, it seemed so benign at the time, but when you think about it in a longer arc of incrementalist measures to neutralize checks and balances, there was a systemic effect. Part of the difficulties for human rights defenders is we operate in silo spaces on our cases on an individualized basis. Part of what the clarion call is now for human rights defenders, especially for the UN Special Rapporteur, who's writing about troubles and sieges faced by human rights defenders, is to mobilize, to get back to the old-fashioned grassroots lawyering of trying to figure out what the systemic human rights impacts are from seemingly innocuous case-by-case interpretations. That's on the legal track, but on the political track, I think advocates and councils have a lot to do as well with human rights promotion and education. We leave the education so much to political activists when the interpretation of human rights is precisely what autocrats are very good at co-opting. And I think we need to hear more from human rights defenders in that space as well.
Let's give the panel a round of applause.